Yes,
Mr. Moult.
my lord, I had been making submissions in relation to Article 2, principally, I think, in reply, although I fear there is a degree of overlap in what I say between those two functions that I have. I hope that doesn't cause unnecessary confusion.
No, but you're going on now to Article 8.
I am. Before I do that, I just wanted to, if I may, just touch on the significance of what Mr. Wise calls the timing point in relation to when NC4 was published.
Yeah.
The significance of it is that it goes to the propriety of the judge's intervention. Because one thing is clear, that firstly, Mr. Wise, understandably, did not base his claim, or indeed found his argument orally to any significant degree on NC4. And we'll see the judge records that in paragraph 68 of the judgment. But secondly, because the judge essentially, I hope this is not impertinent, but it is, I suggest, with respect to him, fair to say he did take up the cudgels himself to a significant degree in paragraphs 63 and 64, and in relation in particular to NC4. And it meant that when he came to decide that he should grant relief in the form of the declaration, he did so without any assistance from the parties in evidence as to what the practical consequences of that declaration might be. And your lordships, ladyship and your lordships will recognise, I am sure, that where the court, of its own motion, in proceedings, and not in reaction to the case made and answered by the claimant and the defendant, takes up a point and then grants relief on the basis of that point, the risk of the law of unintended consequences taking effect is very marked. And that argument is compounded by the fact that the judge was on any view straying in to not the forbidden territory, but certainly the dangerous territory of areas of technical, scientific specialism and expertise, not only for the Environment Agency, but also, of course, for Public Health England, because we have two specialist bodies here. And the judge has intervened to define certain matters as a matter of law without the benefit of relevant evidence to explain what the significance of that might be in regulatory and practical terms. And so the kind of examples that have been considered and discussed and debated during argument this morning, COVID and so on and so forth, are precisely the kind of things that, had the matter been ventilated on the back of a claim that was founded on NC4, that one would have expected the parties to have sought to address in evidence. That's the timing point.
What happened was that the judgment came out in draft before hand down. Before that, there'd been no intimation of there was no, at the hearing, there was no invitation to the parties to consider
the draft declaration.
No,
or not that I'm pretty confident in my
principle of a declaration.
No, my lord, no. I mean, if I have not remembered that correctly, I'm sure I will be corrected. But
my learned friends are right about that, my lord. So paragraph 64, up 1 to 64 came out in draft then, did it? And 65 is what happened afterwards?
Yes.
Okay, because that fits with what he says at 65. But
Yeah. Now, Mr Wise did make some consequential submissions about the wording of the draft declaration, and those are at 66. It was as a result of his submissions that the word daily was introduced into the declaration. The point I make about Mr Wise's case...
And you adopt Mr Hart's submissions about daily, it all depends on the average, or the period that you count for determining the average. You adopt it and say that's another flaw.
Yes. Page 135, paragraph 68 at the bottom, you've already seen this passage, but you see it towards the end of the sixth line up, seventh line up. On the other hand, Mr Wise, from first to last, steadfastly maintained two key definitions. Firstly, he wanted a finding that the EA is in present breach of its obligations, a finding I've declined to make. Secondly, he wanted analysis from this court which accepted Dr. Zinner's zero-tolerance approach, which I've declined to adopt. Mr Wise, you see, did not, moreover, advance as the substantive content of the obligation and remedial solution for this case, the PHP analysis. And the logic of implementing it, even when it loomed large at the hearing. On the contrary, it loomed large because the judge had introduced the concept of a flight path, which took us into fulfilment of the PHE strong recommendations in NC4. On the contrary, it was the EA, through Mr Mould, who identified the importance of the fourth PHE assessment and the implementation of its recommendations. That takes you back to 59. My argument, we've looked at this many times, so I don't need to read it, but what I said in paragraph 59, beginning with if the EA takes actions and so forth, was my response, if you like, to the judge's proposition. And I was saying, well, if we proceed on the basis that those strong recommendations need to be honoured, then the EA will have to approach the matter in this way.
Well, can I just be clear what it is? Because this is shrouded in mystery too. And I meant to ask yesterday, I forgot. Is there anywhere in the evidence where you, the EA, make a clear commitment to accepting that the levels going forward from the 5th of August for monitoring long-term exposure is the PHE ones?
Not in the evidence, no.
Nothing in the evidence. You just said what happens. You said in the course of the hearing that that's what they intended to do to the best of your instruction.
Yes, and exactly. And I certainly, I mean, there's no doubt about it. In paragraph 62, I sought to emphasise through my submissions that the EA had aligned itself to the advice that it had received from Public Health England. You saw that was a point that was made in defence of the claim, and that it would continue to do so. But that wasn't evidenced in a witness statement from the environment. That particular point wasn't evidenced in a witness statement from the environment agent.
So the most we've got is the general you will have regard to and take advice from the EA. And in fact, you, the agency, could in fact decide that in fact they've overdone it.
Yep.
Although you're not intending to do that at the moment, as I understand it.
I mean, the judgment, brings, I mean, your Lordship made the point that when one's dealing with judicial review proceedings which involve a public body, and the allegation is that they are not doing all the things that they should do, the judgment will often record what it is that they have said to the court they intend to do.
Yeah.
And it is open to the court, of course, to say, on the basis of what they have said, we find there's no need to intervene. And
sometimes that crystallises in a formal undertaking.
Yeah.
Sometimes it does.
Sometimes.
That debate never took place here.
No. But certainly, I would expect that this court would, in the light of my submissions, this court would reflect in its judgment, however it disposes of this case, would reflect what I am recorded by the judge as having said in paragraph 59 of the judge's judgment. Because I have founded my response to this, I have founded my appeal in this case on the same approach. That is to say, the EA would be well advised to align its regulatory response to the continuing issues with excessive hydrogen sulphide emissions from this site, to the current recommendations of Public Health England, because it is the Public Health England who the agency, as you know, have accepted is the appropriate body, or the UK HSA as it is now, the appropriate body to give specialist advice on the guidelines that it should be looking to work to in order to ensure that the health risk was kept to an acceptable level, both short, medium and long term.
So, just from absolutely all of 59 is your submissions, including the bit about 8 lines from the bottom on 1 to 8. PHE has made clear and strong recommendations if the EA takes action which have as their purpose and design the implementation, that will constitute a discard. That's your submissions.
Yes.
But more than that, you say on the next page, as Mr. Mould QC submitted, the, not and, but the appropriate standard to evaluate risk is PHE's advice. And the appropriate ways to assess progress is to establish monitoring, take advice and implement it. So you seem to be saying there that this is not an acceptable way forward, it is the acceptable way forward.
And there was no other advice that the agency had as to what, as to the levels that in order to maintain human health to an acceptable level in relation to the operation of this site. There was no other advice to which the agency, in evidence or through me, said it was working to, insofar as this landfill is concerned. So that was an entire what you just pointed out was consistent with and is a fair reflection of what I said. What I did not say was that it was legally necessary to define the margin of appreciation by reference to those recommendations. That's where the judge has taken things.
Yeah.
Well, there's a later reference, isn't there, to, maybe I'm taking this out of context, to your not having, I'm just trying to find it, to your not having taken objection to
Well, he says in 61, I wouldn't flinch at all. I would not flinch at this, all of it is congruent. This is at top of page 130. Right. Your Lordship may have that in mind.
Well, I think there's a later reference still, which is perhaps even firmer than that. I can't find it now.
The problem does seem to be you saying this will be all right, and then that being turned into this is legally the necessary requirement.
That's why we're here.
And not even legally a possible option, but legally a necessary requirement.
Yes. As I say, that's why we're here. And I think in consequential submissions, I invited the judge to pull back and to leave matters with recording what I had said.
Yeah, the reference I think I've got in mind is 68. Maybe I'm misreading the sentence. It's 9 lines up from the foot of page 135 of the bundle. I agree that the declaration stands as a practical and effective remedy. So, with whom is he agreeing there? Is he agreeing? I mean, he's clearly indicating agreement with somebody.
It must be Mr. Wise.
I understood that.
Agree that Matthew was a successful
Mr.
party.
Wise QC
Yeah,
submits on a realistic
So
context
that's
basis.
that proposition, which justifies regarding Matthew as the successful party, as Mr. Mould QC rightly recognises. So, what you were rightly, according to the judge, recognising was that Matthew was the successful party, not that the declaration stands as a practical and effective remedy.
Yes, and I, rightly or wrongly, that was the view I took on the outcome as a whole. That the judge clearly well, the judge clearly felt that himself.
Yes. I mean, but there's nothing in the judgment that indicates, mistakenly, you would say, that the judge had believed you were endorsing his approach of making the declaration.
Well, I certainly haven't read the judgment in that way.
I mean, it wouldn't make the declaration any more or less lawful if you did, but your position is consistent here as it was in the court below.
Yes. I was certainly seeking to reassure the judge that he did not need to follow the course he appeared to be following in terms of his concerns about the agency's willingness to respond to the PHE recommendations. As you would expect, I would have done, but I didn't. I certainly don't accept that I went so far as to say that I accepted there was a legal necessity, if you will, to define the agency's obligations by reference to those recommendations.
My Lord, I think the sentence you were grappling for, and it's not cutting, hesitate to rise, but it's difficult to find the right sentences at times in it, and it's not necessarily a point against my learned friend, but just for completeness. If we go to paragraph 67,
yes,
I think what you're looking for is what's said at the penultimate and last line of that page, of the first page, page 52 of the judgment.
Yeah.
I think that's what you're looking for, but as you say, that doesn't mean that my learned friend was agreed to the terms of the declaration.
Ah, yes, maybe that's what I did have in mind. The EA has not opposed the making of the declaration in light of the substantive content of the judgment.
No, well,
I think that was the passage I had in mind.
yeah, I think that's right. I think we focused on asking the judge to pull back from making the declaration at all, and that's what you see in paragraph 70, top of page 137.
Sorry, just it's a side issue, but it's just arisen from what I was reading. The judge treats when he feels that you ought to be. You said you're going to stick with Public Health England's assessment levels. Another thing that he says, and he goes back to this in paragraph 8 in other places, is that the Public Health England body is the responsible public health body for advice. But does Public Health England have any statutory responsibility for fixing the acceptable levels of hydrogen sulphide emissions?
No, there are. My understanding is that there are not and have never been statutory levels in relation to hydrogen sulphide. In contrast, for example, to the levels which are set in relation to carbon-based gases.
Right, because what the judge says at the end of paragraph 70, says looking to see what else, where he says the judgment of 5 did not find a present breach, blah, 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 blah. The conclusion embodies affords primacy to evaluative judgments of PHE as responsible national body for public health. And it goes back to 8, which says it's the body responsible for giving advice on public health, I think. And Mr. Coetzee says that at paragraph 2 of his witness statement. But nobody's shown us, and we haven't even got in the bundle the EA's statutory powers. We've got some, we've got the regulations, we haven't got section 4, for example, but that doesn't matter. But nobody has shown us what PHE's functions are, i.e. they give advice, or whether they are responsible for saying these are the standards below which people are going to die, or below which people are going to suffer serious health.
Public Health England do not have there is no statutory responsibility that is directly in play here in terms of the production of the risk assessments that Public Health England has produced, which you've seen in evidence. It's certainly my understanding that they are that is work that they have undertaken in fulfilment of their general functions as the public health body established for that purpose. But I don't, unless I've missed it, there is no particular provision in statute that says Public Health England shall provide
Shall fix
Yes.
standards, or shall provide advice as to the relevant standards of emissions for
industrial activity.
which is part of their evidence-based public health, probably called forward-looking function somewhere in the jargon.
I mean, we obviously will, as you've raised it, we will make sure that I'm not misleading you on that. And if there is something, obviously we'll make sure we show it to you. As soon as we can. But that's my position as things are today. Yeah. And the absence of statutory levels in relation to hydrogen sulphide is an established position.
That is established, that's clear from the judgment, and in one sense that's all we need to know. And it's precisely because there weren't any that he wanted to turn this assessment into the relevant levels. Yeah.
Yes. And he obviously was impressed by the fact that in Russia there were such levels, and that in Spain there were such levels.
If there should be such levels, it's not your problem. That would be a judicial review against whichever Secretary of State's responsible for it.
Yes, and it may be that it obviously on the as far as we know, it would be certainly an exercise in producing subordinate legislation, but it may be indeed be an exercise in producing primary legislation. I confess I haven't researched that particular point.
But if it is not your problem, that isn't it? You've got enough to worry about without that.
Well,
you, the agency, that is.
Yes, I mean, in practice, if there were statutory levels,
your life would be easier.
It would be easier in a sense, but it would still leave us with the task of devising a plan of measures, program of measures that were which were designed effectively to
bring them into line.
To bring the operation of this site through our regulatory function into line. Exactly. So it brings you back to the point: how strongly is the EA committed in practice, or in fact, to working to the current advice that it has from Public Health England? And that I submit is clear, unless one is going to say that the only way it could be made tolerably clear for the purposes of the review court is for it to be attested to in a witness statement.
Well, you've got judicial grounds, actually, which say you're going to work with them.
Yeah.
And it's signed by a statement of truth, isn't it?
Well, exactly. Yes, exactly. And that then leads on to the practical difficulties of which is one of the concerns. Mr. Hart made this point, but one of the concerns about the declaration, even if one is in the realms of an advisory declaration. So this, of course, is logically subsequent to the argument that the decision to grant relief here was wrong was founded on an erroneous approach to the application of the European law principles, the CJU, sorry, not CJU, the ECHR principles. But if the court's against me on that point, so we're in the realms of what Mr. Wise calls discretion, then the practical difficulties and the lack of evidence which explains to the judge what the balance of advantage and disadvantage, and in particular the unintended consequences that he, entirely innocently, as someone who doesn't have the expertise that the agency and PHE and others have, that he would not have recognised. Of course, it's not just practical in the sense of scientific understanding. Mr. Hart's clients have a stake in this, and they might have wanted to say something about the practical achievability. You know, they are, after all, the object of the agency's regulatory actions, and they may well have something useful to say about whether a particular course of action that is proposed is actually achievable.
I don't know whether this makes any difference, but I wonder whether one can say that this is not it's not a question of whether the judge happened to have or didn't relevant scientific training and expertise of his own. This is about the role of the court.
Yes, yes.
And the limits to that role in judicial review.
It is, and the submissions I'm making at the moment are designed to, if you like, to identify, I hope with some assistance to you to identify some of the practical problems that arise if, as on our respectful submission, the court exceeds its proper role, even namely to the extent of granting an advisory declaration. Because after all, an advisory declaration given with the best of intentions is still susceptible to these issues.
If it's bad advice, it's unhelpful.
Well, and yeah, it's also, if I may make this point, I think your lordships have it because it's the point you put to me ago, but there's an awful lot in this judgment about what I said, and obviously that carries some significance in the sense that I was seeking to express the agency's position. And I am in no way, I'm entirely comfortable that this court should take what the judge said I said at face value. It would be unattractive and a difficult task for me to do otherwise. But the court will read the judgment fairly in that respect as in all others. And the gist, the essential position I took in relation to NC4 is recorded in paragraph 59. And the essential distinction between my approach and the judge's approach is, I say, illustrated by, as my lady pointed out yesterday, by the choice of adjective, sufficient and necessary. I was positing a factual scenario, no doubt one which the agency would be very well advised to follow, in the absence of good reason to do otherwise. The judge was positing a legal imperative. And
so
that
he
is where
accepts your step 2, but then he basically adds a further sub-step, which is the equation of sufficient and necessary in paragraph 60.
Right. That's the error of law.
Yeah.
That's the excess of that's exceeding the role of the court. Now, can I just deal briefly with the declaration, and then I'll come to Article 8, and then I'm done. The declaration is intended to give a way in which an advisory declaration might be made, seeking to reflect the gist of what the judge was seeking to achieve. So it's very much, if all else in my submissions fail, but in a way that at least cures some of the obvious practical problems created by the judge's language. So it removes "and will." It does not use the word effectively. It allows for the recommendations to change. But the words that Mr. Wise has alighted on and objected to, must act on, are designed to reflect the essential principles which govern the operation of the positive obligation under Articles 2 and Articles 2 and 8. And that is the primacy, that is the margin of appreciation, effectively. That's the way of putting it. It's actually stronger than with regard to, because must do is the language of imperative rather than must act, rather, is stronger than must have regard to. And act, of course, reflects the language of the Human Rights Act as well, which talks about an action or a proposed action. But I don't cleave to my wording to any. In a sense, I say QED. The grappling with trying to produce a form of words that does advise in a helpful way rather than give rise to problems. This is the best I've been able to do.
Well, Mr. Wise posited at least 2 possible meanings of must act on. It may not be a matter on which you wish to make any submissions, but one was, did it mean have regard to? I think I'm just trying to find my note of it. And the other was, does it mean use best endeavours? Those are the 2 I wrote down. There may have been another possible meaning of those words.
I mean, if one's looking for which of those is closer to being a synonym, if you like, to must act on, it's the latter, presumably, rather than the former.
The best endeavours.
Best endeavours, yeah. And best endeavours generally is understood by lawyers to mean money's no object. So perhaps it's almost stronger than must act on.
Best endeavours is at the top of the hierarchy, isn't it? Above all.
It's if you remember in the context of infrastructure planning, for example, use reasonable endeavours means you can take account of the balance between cost and value and benefit.
Yeah.
If you say as far as reasonably practical, it has eventually the same effect as reasonable.
Yes, all reasonable endeavours is higher than reasonable endeavours.
It's essentially best endeavours. Yeah. Because it means that you have to. But best endeavours is the one which is always a source of concern to anybody who is drafting an undertaking on behalf of a railway company or something like that. Yeah. Because that basically means they'll throw as much money as it takes to get the thing sorted.
Yeah. But nevertheless, you say that if we want to synonymise must act on, the closest we get is probably best endeavours.
Probably best, yeah. But as I say, in fact, best endeavours is probably stronger. So it probably lies closer to that, but somewhat below it, because I hadn't intended that the agency would throw as much of its budget as it took to. But I'm afraid that's not a terribly helpful answer. But in a sense, I don't apologise because it reflects the difficulties. I think.
Well, it is a helpful answer because it's a direct answer to the question. But you say this just illustrates one of the difficulties.
The right course here is a matter of principle, and the right course is a matter of judgment. Respect was to leave well alone, and that did not adulterate the protection afforded to the claimant, because the underlying proposition that the agency, the positive obligation would remain on the agency, both under Article 2 and under Article 8, because the judge was quite clear about that. No appeal against the judge's findings that both Article 2 and Article 8 in this case gave rise to positive obligation. And that obligation plainly continued and continues so far as this court is concerned. The court has not heard that that things have changed, and the court is proceeding on the basis of things as they were in August. So, for purposes of this court, those obligations under those two articles contain, and therefore the burden was on the agency and remains on the agency to take the regulatory measures that are appropriate and necessary to.
And I suppose you could add, and I think this really emerges from a point you made earlier in your submissions, Mr. Mole, that there is a published judgment which sets out at some length your submissions on the point.
Yes, and as I say, I have no doubt this court will ensure that, insofar as it considers it appropriate, that it will keep the responsible statutory bodies feet to the fire in that respect. Because, as my lord pointed out to me yesterday at the close of my opening, this case ultimately is about a vulnerable child. And the need to ensure that his interests as victim are properly and proportionately weighed in the balance.
Yes. Indeed. There's a point that's been nagging me slightly, and I will raise it in case it's of relevance to what either side wishes to say on relief. And that is this whole question of liberty to apply. Now, and of course it was covered in the judgment at paragraph 67, but it was covered, as it were, it seems to me it was covered in one direction only. The judge records his agreement with you, Mr. Mould, that this is not an exceptional case justifying liberty to apply. But of course liberty to apply can go in either direction, or both directions. So either side has liberty to apply if circumstances so dictate. Would it in any way mitigate your criticisms of the declaration to contemplate that the judge could have granted either side liberty to apply to the court, should circumstances change?
Um,
In other words, both the claimant and the Environment Agency.
in a sense, the agency coming along 3 months later and saying things have now changed.
Yeah.
It's no longer appropriate to apply these recommendations. We had a different recommendation
Yes.
from PHE. Can you please
Yes.
vary the declaration?
Mm.
Well, in my submission, the problem with that, assuming that it would be in principle something that the court could contemplate, and that's probably right. The Judicial Review Court would have power, I think, to grant liberty to apply, albeit it would do so only in exceptional cases, as the judge has said. But the difficulty is this: it assumes that the content of the declaration that was made was properly evidenced and had been properly debated on the basis of evidence that was relevant to that debate during the hearing. So, if you like, it's a sticking plaster.
Yes, you might characterise it as remediating the remedy.
Yeah, and it does. One might say that in a case with the sensitivities of this case, there is an added imperative on the remedies, if any, that the court grants, being one that is manifestly well-founded, reliable, and can have, on the face of it, a chance of standing the test of time.
Durability.
Durability, yeah.
Demonstrable durability.
Yes. It brings us back to the point that through nobody's fault, and that is a fair submission, through nobody's fault, the court was not equipped in this case, as we submit, to grant a declaration which fulfilled that objective. And that in no way that is consistent with Mr. Wise's undoubted ability and right to bring the proceedings in the urgent manner that he did. Because, of course, his case was that the agency was in breach. It had already failed to fulfill it. In which case, the court, if the court had accepted it, it could have granted a remedy which made that, which stated that. Then everybody would have known where they stood on what had happened, which is, of course, the conventional position in judicial review proceedings.
Yes. That's the conventional position. I mean, we must not lose sight, however, of the circumstances of this case, which is that the urgency had to do with the long-term health under threat of a vulnerable little boy.
Yes, I entirely accept that, and my submission is intended to found on that reality, because had the judge found that the agency had not done what it needed to do in order to fulfill its positive obligations, in other words, accepted the claim as it was advanced, then the judge would undoubtedly have said so, explained why on the basis of the evidence, and would have granted the appropriate remedy. In that case, a mandatory order might have been in order, but certainly a declaration as to what had gone wrong, rather than the declaration we have, which is to do with the future rather than the past. And that's where, as we remember what the Lord Chief Justice said in Bell, that's what declaratory relief is usually for. It's to state the legal position, often on the basis of the operation of a statutory framework or the operation of a contract, but not to make a declaration as to factual matters, which is essentially what this declaration is about, elevating them to legal obligations. Matters of expert judgment, effectively. I ought to get on with...
Just don't forget Article 8.
Article 8.
I've been waiting for all lunchtime.
Yes. I'll try and deal with this swiftly, if I appreciate it, but time is moving on. Applying essentially the same analysis as I did with Article 2 before lunch. Mr. Wise, in the light of the judge's findings in paragraph 56 and 57, Mr. Wise plainly has the basis upon which to assert a potential violation.
The way that I see it, and I know it's terribly tedious, although Article 57 said the Article 8 trigger, I've read the words in paragraph 57 as saying there was an infringement of this child's right to respect for his private life, his family life, and his home. And the question thereafter is whether or not it's justified.
Right.
That's what he's saying. There is an effect on Matthew. It's not minimal. This is a serious effect on Matthew. And therefore, that should be stopped unless you could demonstrate that the steps you've taken are adequate.
Sorry, that's an interference rather than infringement.
Yeah, it interferes with the right to respect within Article 8.1.
Yeah.
We're at the 8.2 stage.
Yes, exactly.
Absolutely.
So you accept that Article 8.1.
Yes,
this is an interference with the right to respect for private life.
There's no
which will be incompatible with Article 8 unless you can justify it under Article 8.2, and you don't result from that.
I don't. Yeah. I haven't sought to challenge paragraph 57.
Yeah.
And indeed, we accepted that was the position at the outset of the proceedings.
Yeah. The question then is whether or not the judge has actually decided that as at either the 15th of July or the 18th of August, the date of the hearing, there was no current breach of Article 8, bearing in mind that the recommendations had started already from March, April onwards about the WHO half-hour things.
Well, on that point, the highest one can put it is to say that the inference from what he says from his reasoning in relation to Part 8 of his judgment, beginning on page 58, what does compliance with the possible operational duties require, and his conclusions as to on the claim is that he wasn't persuaded that there had been. He was persuaded that the interference. Sorry, that there had not been a violation. In other words, that the Article 8.2 balance had been properly struck. But I'd say immediately there is no detailed analysis of that. I accept that.
Well, he treated, in effect, as the steps taken to show you've done everything reasonable for Article 8 purposes, but the same as the steps taken to show Article 8 purposes. Your submissions at 59, which are fully recorded, dealt both with what I call the Article 8 point, the WHO half-hour guidelines, and the long-term consequences. You dealt with both of those, and the judge does accept that if you follow that advice, that's fine. Where I'm having problems, and my problem is the recommendations started in about April, May. 2 recommendations, then 2 strong recommendations, and we've known that the departure is up to 36% at one of the monitoring stations. And there's no finding, you say, that as at the 15th of July or the 18th of August, that those levels amounted to a failure on the part of the EA to rectify them, but without there being any change between the third and the fourth PHE assessment, he does say that for the future,
yes,
it will be.
The inference,
that's where I'm struggling. So if you can help me with that, yes.
Yes, the inference is that no doubt in the light of the evidence he had from the agency, which I'm going to show you.
Good, that would be helpful.
Yeah, I keep talking about it. Right? We
and you, yes.
In the light of that evidence, and in the light of the, and having regard to the World Health Organization half-hour average yardstick, there was, on the facts before him, there had not been, and there was not presently, a violation. The inference from that is that he was satisfied that the agency had justified its position under Article 8.2 of the Convention.
And where are the bits of the judgment that you say demonstrate that he had that was what the judge had found?
I'm struggling. I mean, as I say, the best one can do, I think, on that is to infer that that was his conclusion.
From words like those at the end of paragraph 70. I think it's 70 when he says there has been no breach.
Yes, and in paragraph 64, which is in the body of the judgment itself, it's neither necessary nor appropriate for this court to say that there's a current breach by the Environment Agency of its legal obligation.
What is the position of the appellate court when it can't work out what the court below actually decided on a question of the breach of a convention right? I mean, is there a default that there was no clear finding of breach? Or is the default to substituting one's own finding?
Well, I would suggest that in practice, in this case, certainly, that the court should do the latter, because it is in nobody's interest for this case to be remitted to the administrative court, and so it is certainly within the powers of this court, if it finds that the judgment that is under appeal has omitted to address a necessary step in the legal analysis to fill that gap. And so Mr. Wise's argument this morning was that there is a gap, and he says that gap should be filled in his favour. Yeah. My submissions are that the gap, insofar as it exists, should be filled in my favour, which is what I'm going to hope as quickly as possible.
Yes. Before you do that, I've got two things. I wonder if it's three. Firstly, you're saying that on the first round of the counter appeal, Mr. Wise says that the judge did find there was a breach, and we should follow it through with a declaration. But you say there's no express finding of violation. You can infer from paragraphs 64 and 70 that it hadn't found a violation. And are you also saying, I'm not sure if you are saying, that when you look at the reasons why he went on and did what he did at 63 and 64, the thing that troubles him, and the only thing that he mentions in 63 as to why he can't accept what you're saying, is the absence of reference to the 1ppb. He doesn't refer to the WHO guidelines. I don't.
Yes, that's right.
Them, but he doesn't refer to them as being a reason why he couldn't accept what you were saying at 3. So it's the third factor seems to be the reason why he was unable to accept the EA's position. It doesn't relate to the WHO guidelines. It seems to relate to the PBPD guidelines.
He was focusing primarily on the long-term health position rather than on the odour problem. But I'm certainly able to say, to make the submission, I think, without qualification, that on the face of the judgment, the judge has rejected the claim that there was a current breach of Article 8, just as there was a current breach of Article 2. The point that Mr. Wise has raised is that the judge's reasoning for that is opaque.
Right, I've got a moment. Yes. How can you be so certain that he has said there's no breach of Article 8?
Well, there's nothing. The high point of against me is the paragraph that your lordship put to me, which is paragraph 57 rather, But that paragraph is a paragraph analysing the issue as to whether...
Article 8.1, yeah.
Yes, and that is absolutely clear because paragraph at page 125, we see that this is in a section of the judgment which is asking the question, are the positive operational duties triggered?
Yeah.
So that is clearly the Article 8.1.
Yeah, that's fine. I'm not troubled about that.
Yeah.
It's the other things, but the three things I've written down: no express finding of a violation. The words do not appear. I hereby find that there is a breach of Article 8. 2, the wording in 64 and 70 in particular, he's saying there's no breach. And then 3, the reason for his dissatisfaction was to do with the 1pp B rather than the who. Gosh, nothing but letters. But you know what I'm getting at, yes?
Yes.
So that's that. There's nothing else that one is missing in the judge's analysis of, is there at the 4th of July or the 15th of August a breach? Those are the 3 factors that you rely on.
Yes.
Right.
And
so your next problem then is, if he should he have gone and found out that there was a breach, given what the PHE people have been saying from April, I think, or March?
Yes. Well, should he have explained his position either way on the question of on Article 8.2?
Yeah. Assuming he hasn't done it, and given that you want us to say there is or isn't a breach, the question then is, what are the things that we look at in deciding whether there is a breach?
Yeah. Well, we know...
Is a breach, i.e. there was a breach as at either the 4th of July or the 15th of or 18th of August?
Yes. Can I refer you to the evidence on the guidelines,
Yeah.
and then on the steps taken, and
Yeah.
and then I hope that may assist in, at least in this court, seeing its way forward, as it were. In terms of the position on the guidelines, the agency's position had been set out very clearly in the pre-action protocol letter response. You have that at tab 17 in the core bundle. This was the letter of the 7th of July 2021, response to the proposed claim. You turn to page 259. Perhaps 258, just to set this in context. In this letter, the agency identified the steps the practical measures that it had set in place in order to address complaints, which were primarily about odour. They are itemised at page 258. At 259, we see this. In addition to the above measures required on the site, it is also relevant that significant air quality monitoring is in place. Specialist air quality monitoring equipment was installed in 2018-2019 to enable the EA and partner regulatory organisations to further understand the potential impact on air quality from the site. Summary of findings annexed to this letter. Towards the end of February 2021, the EA also installed 2 specialist mobile monitoring facilities located at Callingale View and Silverdale Pumping Station. These units have been continuously gathering data from the 5th of March. And then it goes on to refer to the positioning of the further 2 units, effectively forming a circle round the site, which will remain in place at the time of that letter until the end of August, obviously now extended. So there are 4 air quality monitoring units in place. They will be monitoring, you see, amongst other things, hydrogen sulphide. And they have the capacity to collect weather data, which is important in determining how gases and odours travel in the dispersed environment. Data from the units have been collated into monthly reports, which the EA shares with Public Health England to provide expert opinion on any human health impacts. It's also shared with Staffordshire County Council and Newcastle-under-Lyme. Weekly summaries have been publicly available in response to public requests for more frequent information. The data has been used to assess the type, time, and nature of the emissions from the site. The data is compared to the World Health Organization 30-minute average odour annoyance guideline level. This is the level above which there are likely to be complaints about odour annoyance. The numbers are the percentage of time the monitoring location has recorded H2S above the WHO annoyance guideline levels. These reports commenced during April 21. A summary table is annexed to this letter. So the position of the agency was absolutely clear in advance of the proceedings being that insofar as gathering data against which to measure exceedances which give rise to odour complaints and measures in relation to that, we are following the WHO.
It doesn't say that. I mean, that's the implication. What it actually says is you're collecting the data, and I looked quickly at the rest of the letter to see where you say, and these will be implemented. I now sound like Mr Justice Fordham, where's the flight plan? I mean, where's my air ticket and my boarding pass?
Yeah.
I mean, they talk about waste, and they say there are additional measures on the next page
Yes.
to reduce non-compliant waste, and there are bits of other applications. And it's just implicit, is that because that's the level at which they're triggering complaints, and you're trying to stop complaints, you must be working to that.
Yes. Yes.
It's implicit.
Then, and it links it to the, as you can see, to the reports published by Public Health England.
Yeah.
I don't need to go back to NC 1 to 4 because we know that that's the level that that's the
level from the very first one, the data which we don't know, but it's got the March, April data, and that says it's above it from the very beginning, and it recommends and later strongly recommends. So nothing has changed about that. All that you know is it's the same or worse throughout.
And then we go to Miss Dennis's evidence.
Yeah.
Tab 12 in the supplementary document. And at page 232, she has a heading, bespoke compliance action plan. At 67, she says, in response to an increasing number of complaints of odour nuisance received from the local community, I developed a bespoke compliance action plan for the interested party from the 1st of January 2021. It was developed in conjunction with a team of colleagues experienced in the regulation of landfill sites, understood that the work required of the interested party needed to provide the largest improvements to deliver a reduction in the potential for the site to cause pollution through odour off-site. And she goes on then to describe what the actions taken under the aegis of that bespoke plan essentially over the remainder of her statement. And so it was 71, a process of driving continuous improvements, reviewed regularly, paragraph 22. It was looking to secure permit compliance, 73. At 73, we see reference to the updated landfill gas risk assessment, landfill gas management plan.
Does the permit have anything in it that corresponds to WHO?
The permit has a specific condition requiring the suppression of odour. That's it's at page 262.
So to go out, so you're saying this, you're going to work with people and so on. Yeah. Okay.
So emission, the condition is as you've raised it. Can we just see that?
Yeah. Okay.
Because the agent, Ms. Dennis's position is looking to secure compliance with the permit. 3.3 odour. Emissions from the activity should be free from odour at levels likely to cause pollution outside the site, as perceived by an authorised officer of the Environment Agency, unless the operator has used appropriate measures, including but not limited to those specified in any approved odour management plan, to prevent or where that is not practical to minimise the odour. So levels likely to cause pollution outside.
And that is the whole, in all reality, the whole 30, because once it's above that, that's what they say it's.
Yes.
So you can treat it as almost synonymous then.
Yes. And what Ms. Dennis says is my actions were directed at bringing this site back into compliance with the permit. So that condition was the relevant condition. So if we go back to 233, she she goes sequentially through a range of practical interventions. The installation of additional gas wells at the bottom of 233. Increase in the area of site covered by capping, and she explains the significance of that in 75 to 84. She refers in 77 to her decision to serve an enforcement notice in order to speed up the installation of capping, see paragraph 78. She considered whether a suspension notice was appropriate in 79. She decided that it wasn't, essentially for reasons of effectiveness. She wasn't satisfied that suspending the acceptance of waste was linked to the risk of pollution, because it wasn't importation that was the key cause. The better course, the most effective course, was to get on with capping works. Then there was the interested party voluntarily curtailed waste acceptance. She refers to the consequences of the enforcement notice at 81 and the improvements delivered at 82. Then she goes on to 83, odour detected on the 7th of May, and the reason for that was identified, and remedial action was taken in June. Then she refers to additional emissions survey work in 85 through to 88, and she refers to action to reduce fugitive emissions from areas of the site which were outside the capped areas, 89 to 90. She refers to improvements required by the agency in landfill gas infrastructure and reporting at 91 to 93, and the service of an information notice requiring rolling weekly monitoring data, see paragraph 92, so the exercise of one of their powers for that purpose. Then 94, requirements to increase the flow of landfill gas utilisation plant by increasing the capacity of the compound. Leachate management, improved amenity controls, and then further consideration given to suspension of the permit. She deals with that in 98 to 100. She explains the enhanced requirements in relation to waste, pre-acceptance and acceptance in 101 to 106. She refers to a review of the procedures for the laying down of waste at 107 to 112. There was a further to further measures following the detection of odour in early March at 112. She refers in 113 to 117 to consideration of revocation of the permit, and explains why that was not considered to be appropriate or effective measure in addition to those taken.
So there are all these measures. There are references to her or another officer of the EA dealing with detecting odour. There's no specific reference to the Public Health England reports or its findings, but you say they're both. I mean, you're saying the WHO deals with detectable odours off the site. That's when complaints are likely to occur. And this is all about stopping that occurring. So whether she refers to it or not, that's what she's doing.
Well, you have, there are two layers to this. You've got the experienced officer site visiting and detecting odours, which is something that the condition that I showed you contemplates, and requiring action to be taken. You've then got the agency providing a pretty intensive programme of air monitoring from March onwards. Firstly, with two.
But I don't see any reference to that, the programme of air monitoring, in what you just showed me off. I just missed it.
We had a separate witness who explained.
Oh, okay.
Mr. Lowe dealt with the air monitoring. That's at tab 21.
Yes, but that explained the practical things, I think, didn't it?
Well, it explains the it explains that the function was to provide for enhanced reporting.
Yeah.
That's at 387.
All I'm saying is I don't get, and you'll say I sound like Mr Justice Fordham now, I don't see any words in what you've shown us from Miss Dennis that expressly refers to PHE, the WHO data that they've got in the PHE reports. She doesn't seem to be saying, we knew things were bad. For example, we knew that there were odours, and indeed the PHE report showed us that. All she says is officials visited the site and they were doing various other things.
But
and it's just a factual question. Have I missed a reference
No, you haven't.
to the word to the letters P, H and D, or have I not missed a reference?
You haven't missed a reference
right.
in her evidence to that. But she is explaining to you essentially the measures that were taken with a view.
And then the question is, why did she take them? And the answer is because they've had complaints.
Yeah.
And then the question that I ask is, would she have been taking more measures if she knew the complaints and the data were at the level of the PHE report? That's what I'm asking myself.
Well, the reason for the reason that the agency installed those air quality monitoring stations around the site was to improve the evidence base, so as to enable real-time data as to the quality of the air, including the components of the component element of H2S, precisely so that it could then share that information with Public Health England in order to obtain advice on what it should be doing. And
but that just makes it even more odd that she doesn't refer to the data and the advice she's got.
well, she does say at 128, the agency will continue to review its position and the response from the interested party in accordance with guidance, relevant legislation. Currently, the interested party is responding to our regulatory action, requiring it to bring the site back into compliance with the permit. So that's the objective she has, which is to ensure that condition 3.3 is complied with. Odour should not exceed permitted levels off site.
Perhaps what we're looking for is the evidential basis for paragraph 59 of the judgment, which you pointed out is your submissions,
yes,
which are threaded through with reference to the EA taking the PHE's advice, and which the judge accepted.
Yes.
So it's really, maybe that it would help the court if we could connect your submissions recorded in paragraph 59 of the judgment with the evidential basis for those submissions.
I think we have two things. Firstly, we have the evidence of Dr. Kurtzy, who was called on behalf of the agency to explain that they had been consulted, asked to offer advice and recommendations, and we saw that he recommended. He explains the applicable values, and he produces the reports. Then we have the evidence of Christopher Lowe, which is at 21, and beginning at page 379. And he explains, as my Lord Justice Lewis has said, in 382 he explains the practicalities of installing the mobile monitoring facilities. And at 24 he says, on page 383, use of the MMFs is critical to collecting high-quality data on the emissions from a regulated site. It enables the agency to confirm if a permitted site is the source of the problem and no other sources are responsible, but also to collect robust scientific evidence. Then over the page, he goes on to explain the selection. And at 386, under the heading monitoring, pollutants monitored. 33 at the top. Installation of the full range of monitors was installed to further support the agency's regulatory activities and to support partner organisations, Public Health England and Newcastle under Lyme Borough Council, for providing additional information for health purposes. Pollutants monitored, based on the technical within the agency and experience gained from similar monitoring over a significant number of years, the following parameters were identified as likely to be issues of concern. Hydrogen sulphide. 38.7, as there's no AQS for hydrogen sulphide, the data collected is compared against the World Health Organization guideline values for both odour annoyance and possible health effects. And then at 40, enhanced reporting. Due to the level of interest in the ambient air quality monitoring, the agency agreed to undertake a different type of reporting for this study. In total, 4 different types of report were produced, varying frequencies. If the levels of hydrogen sulphide exceeded the World Health Organization's average health values 24-hour, we local area officers and public health will be provided with an interim report within 48 hours, and so on. So the
I still don't see a reference to the half-hour one.
No. Well,
I know I'm like a cracked record, but
no. I am simply. My point is that you have Miss Dennis saying, "I'm looking to achieve compliance with the
3.3
with 3.3." She goes through a panoply of goes through a whole series of measures that she has introduced. Focusing on the things that she expects to be effective to manage and control and suppress the generation of gas from the site. You have Mr. Lowe explaining the thinking behind installing the air quality monitoring so as to inform a better understanding of the performance of those measures in terms of the gas generated, including hydrogen sulfide. And then you have and mentioning the partnership with Public Health England in that respect. And then you have Public Health England themselves, through their witness, drawing attention to their role in giving advice and producing the risk assessment reports, which are the product of that advice and which were produced in order to inform both the agency and, of course, the public of progress with the agency's with progress, whether the agency's the measures that Ms. Dennis had spoken to, whether those measures were in fact proving effective. And Ms. Dennis tells us that she had the position under review with a view to securing compliance with the permit. Now, there is not in the evidence the express statement that you mentioned, but there is a chain, or a rope, if you like. There is a rope consisting of a number of strands, which I submit is solid in terms of showing that the agency's approach was one that A, fulfilled the requirement to take effective and practical measures, and two, produced the hard evidence in terms of monitoring data to enable Public Health England to assess the performance of those measures against the appropriate standard. The agency mentioned that standard in responding to this claim in the pre-action notice by judicial and the condition the objective being to ensure compliance with the permit, and in particular with a condition that sought the site, thought that the activity on the site should be free from odor at levels likely to cause pollution.
You're submitting, I think, that when you look at all the measures described by Ms. Sutton,
Ms. Dennis, yes.
Sorry, Miss Dennis, I beg her pardon, and also take into account the relevant evidence of Mr. Lowe, it is clear that in reality what was being done, if you like, maps onto the PHE guidance in the way that you submitted it did as recorded at paragraph 59 of the judgment,
Yeah.
which is accepted by the judge unequivocally in paragraph 60. That's the foundation, actually, for his subsequent conclusion, to which you do take exception, which is that as a matter of legal obligation, the EA should be bound to follow that recommendation or that guidance and none other going forward.
Yeah.
Does that really describe it?
Yes, and it does. I do, and I suggest that that is an entirely orthodox approach, because it is consistent with the conventional approach to the assessment of evidence from a body such as the agency, which says we have a problem which we've identified. We have a standard, which a regulatory standard that we have imposed, which is the condition on the permit, and we recognise that there's an element of subjectivity, if you like, in as my lord put it, in terms of simply relying on site visits. So we have installed, because of the level of complaint here, monitoring equipment that gives us real-time objective evidence, hard evidence, which we then provide, we then share with Public Health England so that we can obtain their assessment of the degree to which the measures that we have instituted with a view to securing compliance, whether they are, whether those measures are producing the results that we intend them to produce.
So the key is 3.3 actually, and that's how the Environment Agency would work. You can't have odours off-site. There are going to be arguments about whether there are odours off-site or not. So the condition says perceived by an environment officer. You've gone, you say, one step further by getting backed up data. And there's not going to be the discussion, oh, you can't say there's a breach of Article 3.3, you weren't there. You will turn around and say, don't be silly. The reason why we've got these monitoring stations is precisely to get the levels.
Yes.
So it's a better way of meeting 3.3, not a freestanding separate standard that's come out of the air.
Yes.
Bad example. I got it.
Which then...
But what the judge should have done, and what you're saying we should now do is consider whether that argument is right, and if you've got a condition designed to stop odours off-site, and if you've got the person, Ms. Dennis, saying this is what we've done to stop it, and you've got somebody else saying, and we've been measuring it, the reason why you're doing all of that, you say, is actually to stop odours off-site.
Yes.
And that's what you say we should do.
That's
the other mystery that I've got, that's helpful thing about it. The other mystery that I've got is, how can you have a declaration saying you must stop it as soon as possible if it exceeds who, and not have a finding of breach as at the 15th of July or the 18th of August? Because the recommendations have been in place and haven't changed, and the levels have never been within acceptable levels all the time. So either it was a breach before, or why is it now a breach in the future? Or is it just because it'll have gone on for months?
Well,
I'm mystified by the apparent confusion or contradiction.
In a sense, you're putting it an open door on that one. But I suppose that one might say that it should be read as soon as reasonably possible. In other words, there's a recognition that the regulator can. There is a limit to what the regulator can realistically achieve. I mean, as soon as possible, all measures as soon as possible mean it must be read in the context of what is humanly possible. It brings us back to it, in a sense, to the timing question. If the agency was doing nothing, or the evidence showed there was plainly more, as Mr. Wise put it, much more that the agency could have done that it was not doing, that they had a real prospect of speeding up the achievement of the objective, then there would be an argument that the agency had failed to justify the position under Article 8.2. But there is no such evidence. And so the only reasonable conclusion, my submission, is that the evidence I've shown you is evidence that the agency is taking the appropriate and effective steps to get the levels down to the recommended levels, which the recommended standard, as soon as possible. It's taking longer than ideally one would wish, but that is the product of action by the agency rather than inaction by the agency.
What happens if there's a dispute over as early as possible? I mean, if the Environment Agency says, well, this is being done as early as possible, and the claimant, or for that matter somebody else, says it's not being done as early as possible, and for that matter the site operator says it's being done as early as possible, I mean, how is that dispute to be resolved?
If it's the site operator and the agency considers that the site operator is actually not doing things as soon as possible, then the agency can consider serving a notice alleging a breach of Condition 3.3 and requiring and enforcing. And then there would be a right of appeal, and the question for the if the appeal was made, the question on appeal would be whether the agency was correct.
So what we've got here is we've got matters of expert judgment in one dimension of this, and we've got matters of statutory control, formal statutory control or enforcement in another aspect of it.
Which, as you know, are based on an exercise of an expert judgment in any event.
Yes. Which rests on an expert judgment.
Yes.
So they're both, as it were, embedded in this declaration.
Yes. And the prior question as to, I mean, there is clearly a potential legal remedy. There's a route to a legal remedy if a party considers that things are not being done as soon as possible, and that is a claim under the Human Rights Act.
That's right.
And that's the claim that was made in this case.
Yeah.
Because Mr. Wise's claim under Article 8 was you haven't exercised your powers adequately in order to fulfil the objective of getting the odour levels down. And Ms. Dennis's aren't evidence, and Mr. Lowe's evidence, and the evidence of Dr. Coatsy is our answers. We say that we are. It falls, I'm afraid, to be analysed under the principles which govern Article 8.2. In other words, there's a fair balance component to this. But nevertheless, that as we saw in Fadieva, is able to encompass the court making a judgment that although there is a margin of appreciation, it's been exceeded. And one can see that in a case where the court thought there was clear evidence that the agency had failed to take a step that it plainly ought to have taken, that would be a basis for saying that the margin of appreciation had not been, that it had gone outside the margin of appreciation. And that was my submission on the legal structure yesterday.
Yeah.
But I said that when I showed you this material, that I hoped that this would shed some light on how to proceed, and I suggested that whether if you take the view that if you're going to analyse whether the judge has made findings and drawn a conclusion on the issue of current breach within the framework of Article 8.2, that is to say, a legitimate purpose, there's no issue about that, but necessary in a democratic society with fair balance, then this is the information which I suggest you will look at in order to...
And you say, just so I got it straight, the judge certainly didn't find, according to you, a breach as at the date of the claim of the hearing. and either he's not explained precisely why he thinks that in relation to Article 8. He's only precisely explained it in relation to the new recommendation for long-term consequences. And we've put to one side the apparent discrepancy between that and the declaration, and we ask ourselves the simple question, even though we've become obsessed by the fact that there's no reference in Ms Dennis to PHE guidance, if in fact the whole purpose of 3.3 was to stop offsite odours, and if the whole purpose of monitoring was to have proper data for that, it follows as night follows day that that's what the measures were designed for, and couldn't have been designed for anything else, really.
And I appreciate you had some misgivings about the reference I put to you in the pre-action response letter, but that is all of a piece with drawing attention to that.
Only a letter. There's nothing in the detailed grounds so clear, and nothing with a witness statement or a statement of truth. And I really like evidence, not letters.
Okay, well, no, but it
and the
was a way
pre-action
in.
protocol response is what it is. It's
Yeah.
a response by a lawyer in an office.
Yes, well, on instructions, no doubt. But well, in that case,
It's really Miss Dennis and 3.3, I think, and Mr Lowe.
And Mr. Lowe and Dr. Coetzee, because he's.
But he doesn't say. He's got 1.5 paragraphs about the WHO 2 guidelines. That's the problem.
Yes.
Everyone runs them all together, but if you actually read the words on the page, there's not a huge amount from Mr Coetzee, to be honest. He says what he says on page 394, paragraph 12, no, paragraph 13. The WHO odour analysis was also used. It is possible people would experience symptoms as a result of odour. See further below. And then there's a bit more about odours in 14. And he says, as the sulfide concentration increases, more people will be expected to have symptoms. And that is the extent of it, unless I've missed it.
Yeah, no, I don't say.
So I don't see much there that helps actually in analysing. Everyone knows that these guidelines exist, and everyone knows that the monitoring is taking place. What Mr Wise is complaining about, and what Mr Justice Fordham and now me have become exercised about, is the link between the guidelines, the monitoring, and the steps on the ground.
Yes.
And I think we've got to the stage where you're inviting us to infer that there must have been a link, because the whole purpose of the guidelines and the whole purpose of Condition 3 was to stop offside odours, leading to complaints.
I am inviting you to consider the evidence as a whole, and to see that there is an obvious link between the steps which Ms Dennis speaks to with the avowed intention and objective of securing compliance with the permit. I've identified the particular condition in the permit to which governs odour control from this operation. I've identified the terms in which that condition is expressed. I've identified the role of the monitoring stations, which is explained by Mr Lowe. And I'm inviting the court to conclude on those facts and on that evidence that the
taking reasonable steps to stop pollution.
To stop pollution, and that the guidance, the guideline that is in play, and which the air quality monitoring is designed to inform, is the World Health Organization half-hour guideline. Yes. So I'm inviting you to find those facts, and on that basis to conclude that the fair balance has been struck. There, incidentally, paragraph 2 of Dr. Coetzee's evidence gives a little bit of factual information about the role of Public Health England.
Yeah, he does say about it there, yeah.
So, whether it's a case of eliciting a rationale to support the judge's findings to which you've referred, or whether it's a case of saying that this court needs to make that find those facts for itself, and then on that basis to make its own judgment. That, I suggest, is the material which
we've got.
is relevant to your consideration of those questions.
Yeah, and we have read it, as you can tell. We promise you, we have looked at it on.
Yeah, no, I understand. Just for your note, two documents that haven't been referred to, but which do inform Miss Dennis's evidence, are the programme of landfill gas management activities, which were set out in the revised gas management plan submitted at the end of July, and that's at page 319. And it was that timetable of works that I drew to the attention of the judge to show that the timescale for the current programme of activities was until the end of the year. And then that document is in part informed by the plan at page 321, which shows the proposed infrastructure works, particularly I think focusing on gas installation.
Do we have in the bundle the 30th of July interested party plan?
We don't have the revised gas management plan, no.
I thought I might have missed it, but
No.
I haven't then, don't worry.
No, that wasn't included in the bundle, no.
It's all right.
I think it is touched on in the evidence of Mr.
It's in the evidence and it's discussed, but I haven't seen the plan. But I wouldn't understand it, so I wouldn't worry about it.
There is as you will have seen, there is a witness statement from the Group Operations Director at Lead Industries, which is at tab 9, which gives some information about that.
The document that's on page 319, which I draw your attention to just now, is dated the 29th of July, but is said to be a live document which should be updated regularly.
Yes.
Was that its current version at the time of the hearing? I assume it was.
Yes, that is certainly true, because it bears the bundle reference number, EF page number D323.
Yeah. So what was being, for the planned start dates for the pending activities, which extend as far as the 31st of October, were the current status of those planned activities as at the time of the hearing before the judge?
That was treated as their current status.
Yeah.
Yes. And those were activities that were included within the draft revised gas management plan that had been submitted at the end of July.
Yes.
And so that explains why it dealt with in progress or pending activities.
Yeah.
There are things, as Ms Dennis has explained in her evidence, there were things that hadn't been done before that.
Yeah. I mean, if we are, perhaps I'm following a false trail here, but if we find ourselves in the position of having to make our own decision on Article 8, this evidence suffices for that purpose as part of the evidential picture.
Yes, the spectre of having, I mean, your Lordship has in mind, I think, that you would be making that decision on the basis of information that was current as of mid-August, but being asked to make a decision on that in the end of the year.
In December, yeah.
That must be right, because of the nature of these proceedings.
Well, we're not asking. We're not asking, I think, for more evidence.
No.
But I simply draw that to the party's attention.
It would clearly be. Sorry.
Just pause for a second, if you will. Thank you very much.
Thank you. Would you just? I've just been asked to look at one point.
Oh.
I'm so sorry. Bundle. Yes. Well, it's perhaps just a contextual point. I'm reminded that in the statement of facts and grounds, the allegation at this is page 249 in the core bundle, was that there's a certain irony. The allegation you see at 78 Roman 1 was that the defendant had focused on odour emanating from the landfill and had not considered, and as a result had not given sufficient consideration to health. You see that reference at the top of the page.
Yeah.
Right.
Thank you. Those are my submissions.
Thank you very much, Mr. Mould.
Nothing on Mr. Mould's declaration.
Thank you very much, Mr. Hart. So the final word, I think, comes to you, Mr. Wise.
Yeah, thank you, my lord. I have some ground to cover, and I'll try and do it as quickly and efficiently as possible for the court, especially bearing in mind the time. Just a very quick point on the line from Mr. Hart's brief comments before lunch about the possibility of something going wrong on the site, such as a gas exchange or a gas flare. Of course, one would expect that contingency to be built into the planning and to be accounted for. His main complaint appeared to be about the daily concentrations and the way that the judge formulated the matter in the declaration. He did so because that's the way it's formulated in the US EPA guidance, and the judge did in fact send us the US EPA guidance, all 250 pages of it. I think after the hearing had finished. No, it wasn't. It was after the end of the second day. I apologise. And invited the parties to make submissions. I made submissions, but to the point, this point wasn't. No submissions were made on behalf of the interested party about that, and neither were they at the draft judgment stage. And so that opportunity had been available to both the appellant and the interested party, but they didn't avail themselves of it. Your Lordship, Lord Justice Limbaum's point about liberty to apply, with respect, we will say, is a good one. It was something we've been given consideration to on our side earlier today. The difficulties with the practicality of a declaration could, of course, be addressed by liberty to apply. And as my Lord correctly said, liberty to apply can apply to all parties, and you see that we applied the liberty to apply. And it was open to both the EA to apply for that, and the interested parties to make representations for such liberty to apply. And that factors in, I think, to the submission I made this morning, that the declaration inevitably has difficulties which have been identified, and that would be one way of ameliorating those difficulties. Moving on then to learn from Mr. Mould's submissions, he said that our claim is based on the alleged breach based on Dr. Sinner's report. Of course, we primarily base our case, at least on appeal, on the judge's findings on the impact of the current levels of emissions on this child, and the court has that at page 56. My learned friend then took the court to two aspects of the Article 8 duty so far as we were concerned with. Those the framework obligation and the operational obligation. Framework obligation is of course important, and we haven't touched on this in the during the course of this appeal, but it is important to recognise that in order to comply with the framework obligation, there must be in place a framework which enables the Article 2 obligation generally to be complied with. And what that means in short is that there are in this context, the Environment Agency has the powers necessary to adequately protect life for the purposes of Article 2. Now, of course, a part of that framework, albeit not part of the statutory framework, is the role of Public Health England, and one builds that in. In this jurisdiction, we've gone down a different route than other jurisdictions in that we don't have statutory emissions limits that are relevant to landfill gases such as hydrogen sulphide, but that may not matter, and in fact, indeed it may be, of course, a better way of doing things in that the matters delegated to a professional, scientific and independent body such as Public Health England, rather than being regulated directly by Parliament. But that's by the by. The point is, they have the framework is available, and as the judge records, the Environment Agency has the powers and had the powers that were necessary in order to bring the emission levels down to safe levels. I'm going to come back to that in a moment, but just taking in the points that my learned friend made. He then reiterated his point about the choice of measures being for the regulator, but doesn't deal with our submissions. That was of course built into the declaration and something that the judge very much had in mind. We then have consideration of what Miss Dennis says. He made reference to Miss Dennis's evidence before and after the short adjournment. What's important about Miss Dennis's evidence that the court hasn't been shown is what she says about what could be done. And if I can take the court to it, there's a couple of paragraphs towards the end of her statement which my learned friend didn't take the court to, which I'd like to show you if I may. And it's particularly the last two paragraphs of her statement. It's page 249 of the supplementary bundle, paragraphs 138 and 139. And essentially what she's saying here, in conclusion, following on from the paragraph that my learned friend took you to a few moments ago, is that she's saying it's essentially a matter of an iterative process of continuing improvement. And the very final sentence, as the court will see, says the agency will continue to require the interested party to make improvements to reduce emissions in the shortest timescales possible. And what that means, of course, is that there's more that can be done. It's a softly approach. There's plainly more that can be done, and that's what she says is going on. There are measures being taken, more wells, some capping, and so forth. The emissions remain stubbornly high, and so they look, review it and see if there's any, see what other measures should be adopted. But of course, that's not good enough, because the ongoing danger to my client remains, despite the fact that there is more that can be done, even on the Environment Agency's own evidence. My learned friend then spent some time taking the court through the PHE reports and focused on the intermediate level that PHE were concerned with. which is one of the measures that they were concerned with. Initially, of course, the point that was being made was that PHE were contrasting the situation in the first 364 days with the situation that would be pertinent beyond the 12-month period, and drawing to the attention that different levels would apply. But of course, the PHE don't only focus on the intermediate and long-term levels. They make recommendations with respect to the half-hour levels, as your lordships and your ladyship has seen. And what's important is that the intermediate level, the daily concentrations of 20 parts per billion in the daily levels, is in the intermediate levels, is anticipating a long-term or intermediate up to 12 months relatively low concentration, which could of course be 2 parts per billion for the best part of the day, which would be or for say 18 hours a day or thereabouts. That doesn't accommodate the spikes of over 5 parts per billion for over 30 minutes. And that's what we're concerned with, of course. And it's those spikes that lead not just to odour problems, but to all sorts of other health problems, including mental health problems, that Public Health England recognise and therefore make the recommendations and strong recommendations that they do. So, with respect to my learned friend, we'd say his focus on the intermediate levels is a red herring in this case. My learned friend then went on to make what we would say is a surprising submission that we can't look to Public Health England's risk assessments and point to a present health-based risk, or that the levels lead to a violation of Matthew's Article 2 rights. But of course we can point to the present health-based, the risk assessments and point to a present health-based risk. That's exactly what the 30-minute exceedances show.
Hold on. The 30 minutes I understood, and I asked you this yesterday, the 30 minutes is significant odour complaints, and then there's a nuisance because they can affect people with watery eyes and so on.
Yeah.
But when you're talking about the risk to life,
absolutely, my lord. Yes,
it's
yes.
the short term, where it's acute,
yeah.
intermediate, and if it goes on for more than 365 days.
Absolutely.
And we haven't seen evidence, even with this child's needs, that the 30 minutes is going to shorten life expectancy.
2 points about that. First, the point I was making there, that's evidence of health-based risks, even though it's not potentially fatal. The 5 parts.
I did go through this with you yesterday, and I had clearly written down that the WHO 30-minute guideline goes to Article 8, not
yes,
Article
it does.
2.
It does. But the point that my learned friend made, and I'm responding to, is that there's no evidence of a present health-based risk, which is a health-based risk.
Well, then it's words. Article 8, if we put Article 2 health risk or Article 8...
No, it doesn't have to be life-threatening to be a health-based risk.
No, I understand that, but it doesn't...
Well, that's the only point I'm making. I'm just drawing the
Article
distinction
2,
between health generally and whether it goes to the extent of it being life-threatening, my lord. But then your lordship says, well, there's no evidence that the levels were a risk. But of course, the judge made a finding, which isn't appealed, that Matthew's non-recovery, which will inexorably lead to a shortening of his life, is attributable to current levels of hydrogen sulphide exposure from this quarry. That's paragraph 56. Your lordship's report seen it on a number of occasions. Your lordship have that towards the bottom of page 44 of the report.
Yeah.
It's the one to it's the bottom 4 lines there. So that is evidence of health-based risk, my lord. The learned friend then said that the judge has taken Public Health England's recommendations and defined it as a positive obligation. Well, of course he has. And this is the point we were making, hopefully at length this morning, when we were considering what the content of this positive obligation is. The judge read in the Public Health England's recommendations because the Environment Agency had accepted that they would act on them, and that they were therefore a good measure of what was required under the positive operational duty. He was merely, it wasn't a judgment that the judge made himself. He was merely utilising the position of the EA to determine the content of the obligation. And I'm reminding my Lord, I think it was Lord Justice Lewis, said at one juncture this morning, asked at one juncture this morning whether there was a plan before the judge at the time of the hearing that dealt with the 5 parts per billion World Health Organization recommendations. The answer to that is simple. There wasn't any plan before the judge. All we have is the points that my learned friend took you to in the court to in the evidence, which is the general evidence of Miss Dennison and Mr. Mrs. Dennison and Mr. Lowe about the measures that the reviews and the measures that the EA are taking. Nothing of that goes specifically to a desire or a desire or an attempt to achieve the WHO recommendations. Based on, certainly it's based on odor limits and 3.3 in the permit as the court's seen. But odor limits aren't defined by the WHO guidelines. They're guided by what I think in the evidence is called the sniff test. Environment Agency officers going to the parameters of the site and seeing if they can smell any odours. Well, that might have some utility, but it's not an objective or permissible, we would say, way of justifying the ongoing problems that have arisen from this site. My learned friend said subsequently that the court isn't equipped to make a declaration in this case, but of course it had to grapple with the issue that was before him. It had been accepted that was an interference in the rights of this child. It had to do something about it. It couldn't just abdicate its responsibility, I think is the word that Mr Justice Fordham chose. It took a different. The judge took a different route than we proposed, but nevertheless, as we said this morning, it's not one that could be said was an error of law. My learned friend then turned to Article 8 itself. And my Lord Justice Lindblom raised the question of what's the role of the appellate court if the lower court's got it wrong in a convention manner. And I'm reminded of a judgment of Lord Justice Buxton. I think it was a case of we'll try and look it up overnight. Fairly long and complex judgment. And there was a controversy at that time as to what the court does, particularly in proportionality cases that are on appeal. And there was some conflict between the cases as to whether the court should conduct the proportionality exercise themselves, or whether they should firstly determine whether the judge of the lower court had made an error. Only if the lower court had made an error that the appellate court should proceed to make that judgment themselves. However, I also recall that recently Lord Sales made a speech questioning whether that approach is correct. I can turn it up to you, Your Lordship. I think it may well have been last year's annual election,
yeah.
my Lord will recall. And I think the gist of that speech by Lord Sales was, as one would expect, it depends on context, and there are some issues of such wide importance and of such general application that it would be wrong for the more senior judges not to be making the decision. So that there's frankly there's a grey area there.
But if our ultimate decision is that the judge found that there was no breach as at the date of the hearing of Article 8,
yes,
then we'd be on to your argument, he should have made such a breach.
Yes.
And then on conventional principles, we would be assessing whether the judge was wrong on the evidence before him.
yes,
In,
that's what we're submitting to you.
It only arises if he's failed to deal with Article 8. The question of who goes first in deciding whether there is a breach. If he's decided no breach and you say it's wrong, we'll see if he's wrong. If he hasn't considered Article 8, then the question is whether it should be considered by us for the first time or sent back to a High Court judge for him or her to consider it for the first time.
I think the parties agreed that certainly the most convenient way would
For us
be
to do it.
for this court to do it. I think the court has a general
We can exercise the powers of the High Court.
has the power to do that if that's necessary. And the final part of section of my learned friend's submissions were with relation to which picks up from my Lord's point just now, why he says this court should find that there wasn't a breach, and he pointed to a number of things. The pre-action letter, which we say is irrelevant, it doesn't show why there wasn't a breach at all. More substantively, he refers to Mrs. Dennis's statement and the compliance action plan. The compliance action plan, of course, is compliance with the permit. But there's nothing whatsoever. We don't have the compliance action plan, incidentally. But there's nothing whatsoever in her statement to show that the Environment Agency had addressed their minds to these levels. And that's particularly concerning because of the ongoing breach and the ongoing stubbornly high, is the way I would describe it, levels of hydrogen sulphide emissions from this site. We went through the risk assessments yesterday and saw that they were consistently at a high level of around 30% or just above. And it's surprising that there's no evidence whatsoever that the Environment Agency hadn't addressed their minds to the measures that they could take to bring that down, especially in light of the recommendations and strong recommendations of Public Health England. My learned friend, in terms, invites the court to infer from the evidence that the agency has done what is necessary to deal with the interference, and we say that inference simply can't be good enough to satisfy the accepted interference with my client's Article 8 rights. These are fundamental rights. I don't need to remind the court, and to deal with them in such a cursory manner just simply isn't good enough for a responsible public body. My learned friend said that there was no evidence that the agency could do more, but I took the court a few moments ago to Miss Dennis's statement, Mrs. Dennis, sorry, I apologise to her, statement that that in fact she was saying that they could do more. They were continually monitoring, and if they didn't bring it down, that they would do more. So that it obviously flows from that there was more that they could have done, and so that doesn't assist my learned friend at all in justifying the ongoing breach.
Well,
to
Mr.
match
Wise,
the
it's the
track.
second time you've referred to an ongoing breach, but why do you keep talking about an ongoing breach?
Because the
Hasn't been a
levels
finding.
above 5 parts per billion, my lady, were first identified in the first risk assessment and continued right through until the fourth assessment. And there's no evidence that that's been addressed. This isn't a case where there's a breach at a particular time, an incident has happened. It's an ongoing breach.
It's an ongoing situation. It's a continuing situation.
Yes, well, sorry, my lady.
Sorry, ongoing breach of what? What? I just want to be sure what
Article 8, my lady.
So it's an ongoing breach of Article 8, even though the judge found that it wasn't, or
Yes.
didn't find it.
Well, that's our
All right, that's your
it's wrong,
formulation.
not
All right, okay. Well, it's just so unclear what you're saying. Okay, ongoing breach of Article 8. All right.
I think I've attempted to cover in short time all the points my learned friend made in reply. I don't know if there's anything else I can assist the court with.
Yes, could you just help me? It's probably my fault, and I probably failed to take note at the right moment. Could you just help me, please, Mr. Wise, with paragraph 56 of the judgment?
I will if I can, my lady, yeah.
So, at the bottom of the page, halfway through paragraph 56,
Yes.
the judge, subparagraph 3, the judge draws 3 conclusions
Yes.
from Dr. Sinner's report. And I just
Yes.
wasn't sure where in the report Dr. Sinner makes those precise points. And it may be that I just haven't read the report carefully enough. Are you just able quickly to tell me where those points come from?
I'm not off the top of my head, my lady.
No.
It may be, and I will certainly look it up overnight and let you know, but it may
Yes,
be
that would be really.
it may be that
really
that's
helpful.
derived from the live evidence, because Dr. Sinner did give live evidence.
Oh,
of
I
course.
see. All right.
I don't know if you picked that up. But certainly
That would be really
we'll give that a.
Thank you.
It's a long, detailed report from Dr. Sinner.
I
as
know,
well,
and I was
need
just
to,
having a quick look at it, and I couldn't see it immediately. But
But that was the judge. What the judge found, of course.
yes, I know, but I'd just be interested to know what its basis was.
Which is a very convenient and appropriate place to finish on, because that finding is of course, at the heart of this case. The ongoing threat to this child's life, and I'm sure all the members of the court will have that in the forefront of the mind in determining this matter.
Thank you. Thank you, Mr. Wise.
I take it it'll be a reserved judgment.
Well, would you just allow us a moment to reflect? Mr. Wise, in answer to your question, but for the benefit of all parties, the court would be assisted by counsel on this question, and that is whether, if it were possible for us to give an indication, not to give an indication, actually to make clear our decision in advance of handing down a reasoned judgment, whether that would be of assistance in the circumstances, given the whole context of urgency and given in particular the terms of the relief granted in the court below, this being on that basis an unusual case on any view of it. So that's a question for the parties, and counsel may be able to help us on it.
Does your lordship want an answer to that now?
It would help us,
Would
yes.
you just give me 1 moment?
Well, do take instructions, by all means, yes. And if you want more time to take instructions, we can rise and go out of court and come back in.
Would you mind if it's a sensitive matter, would you mind if I had 5 minutes?
Not at all, no.
Well, if Mr Mould knows the answer already...
No,
you don't know the answer.
The same.
Oh, you need to.
welcome
Well,
the
So I thought you were about to tell us, not to tell with the mask, whether you're a person to speak or...
sorry.
No. I keep forgetting to put mine on.
Yes, we do.
Will 5 minutes be enough? You've got to make a telephone call.
Yes.
Well, no, I've got my solicitor behind me.
Oh, I see.
Yeah.
I'm sure it'll be enough for me. Yes.
All right, well, we'll come back in at 4:20 and receive your answer to your answers, I hope a single answer, to our question.
Thank you.
Thank you. Until 4:20.
Oh, mind you, are we live streaming?
I don't think we do that.
Yeah, what's going on? Yeah, really, what's going on?
Exactly.
Right, well, that's brilliant.
Yeah.
We've got
I assume David will have the same. We do for it.
yeah. Oh, gosh, we've been so quick that we're early now. There we go. Yeah, Tim and I both think as soon as possible. Agreed. Yes. Right. Yeah. So I'll tell the court. Yeah. Could you tell them when we're ready? In case they're just outside.
Absolutely. Yeah.
We all want an early Christmas present, don't we? That's why I got this judgment.
This indication.
Yeah, right, it is the outcome, but it's not
Yeah.
the indication.
Reasons to follow. This is what.
Yeah. I mean, it's a bad practice because often you work your reasons out, as you know.
Court rise.
My lord,
Yes.
my lady.
Have you all had time to
yes,
take
we have.
instructions? Yes.
We've all taken instructions and we've just had a brief discussion amongst ourselves as well. You'll be glad to know there's unanimity on the front row and across the court generally. We would all be, we would all wish to have an indication as soon as possible. And I think the general consensus is as soon as possible, i.e. the next few days, certainly before Christmas, if that's possible.
Yes. Well, if it is possible, we will notify the parties that we are able to state our decision in open court on a day and at a time that will be indicated. Whether that will involve physical attendance or need not involve physical attendance, we can deal with, I think, in the meantime. But in the light of what you said, Mr. Wise, and that being the consensus among the parties, we will keep that in mind, and if we are in a position to do that, we shall do it.
Mobilise more. Just one final thing with respect to attendances.
Yes.
Given that there's going to be no consideration of any consequential orders at that time, can I suggest the presumption is that no attendance is needed unless the court indicates that they want.
Well, they do need to be helpful for somebody to be there to note the decision.
Yes. Somebody should be in court to note the decision.
Yeah. Well, no discussion.
But I think counsel need not attend. Agreed?
Or juniors, I suppose, rather than leaders.
I think we'll leave it on the basis that counsel need not attend, but there should be a representative of each party present in court, if we are able to do that, to note the decision of the court. I think that's the correct way to do it. Very good. Well, thank you all very much. What we can say in any event is that we're most grateful to all of you for the very clear written and oral submissions we've received from you. Thank you all very much. When I say all, I include all counsel and, of course, all legal representatives too. Thank you very much, all of you. There's nothing else we need to deal with at this stage, as far as I'm aware. Thank you all very much.
Court rise.
Well, otherwise if we don't